Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. For the next half hour, we have a panel of experts assembled to deal with a topic that we would love to include you in. There are ways all throughout the program that you can call, text, email, encourage you to do that. Also a reminder, there's an attorney standing by to speak with you live for the next half hour. So a pretty neat opportunity that I would encourage you to take advantage of. Leading our conversation from the firm of Hollis Wright, Carter Clay. Good to see you, Carter.
Good to see you, David. I hope you're doing well.
Doing well, thank you, sir.
We're going to talk about alternative dispute resolution this evening. And lawyers, as you know, have a tendency to complicate things, and so we came up with this fancy way to describe a problem-solving mechanism outside the courtroom. And that's essentially what we're going to be talking about tonight, because as you know, the courtrooms are clogged. If you file a case, it's difficult to get your case to trial. In the circuit courts throughout Alabama, if you file a civil lawsuit, it can generally take anywhere from about a year to 3 years to get a realistic trial date for your case, given the other number of cases that are pending before a particular judge. Right. So it can be a very time-consuming process. We've got budget issues right now facing the courthouses throughout the state of Alabama, which only aggravates the situation. So several years ago, lawyers and others came up with different ways to explore resolving disputes outside the courtroom. And that's essentially what we're going to be talking about here this evening. And we're very fortunate to have a very prominent lawyer in our community named Ken Simon with us to talk about alternative ways to resolving disputes outside the courtroom. I won't tell you exactly how long Ken's been practicing law in this area, but he's been doing this for a number of years. Before he got into resolving disputes outside the courtroom, helping people resolve disputes, he represented clients just like we do. He defended cases and defended companies and defended individuals, but over the last several years he really got involved in this process, and I think you do that pretty much exclusively right now.
That's right, and not only have I defended cases, but I've represented plaintiffs in lots of cases also, so I've had a lot of experience on both sides of cases as a lawyer, but also spent several years as a trial judge here in Birmingham. And it's really given me a good perspective on what the whole process is about, but also a perspective on the advantages of trying to get cases worked out of court. Mm-hmm. So
how did you, give us a little background, how did you transition from practicing law into doing mediations and arbitrations and things like that?
The transition really started from the time that I was a trial judge. I was a circuit judge here, and I would say that I probably tried about 100 or so jury trials and probably another 100 or so non-jury trials. And this was in the early 1990s. And as you said, Carter, the bar came to a realization that, hey, look, this has taken too long. Not only does it take too long and our courts are clogged, but it's also very expensive, not just for the system, but also for the litigants. So you, as a plaintiff's lawyer, might have to expend an enormous amount of money before your case ever comes to trial. And that ultimately becomes an expense that the parties, that the plaintiffs and the defendants have to bear. So the bar came to realization that, hey, look, we can do this in a smarter fashion, and mediation is a smart way to do things. So when I left the bench, I more or less got on the bandwagon with the bar, and we came to a point where it was really slow going, getting everyone to accept and understand what alternative dispute resolution was all about. Back in those days, people really didn't know the difference between a mediation and an arbitration. But I now think that everyone's pretty much on board. They understand what it's all about. And my transition involved helping educate the bar at seminars and retreats, but also as a practitioner of alternative dispute resolution. It gave me an opportunity to work with lawyers as we all learned together how to get cases mediated and which cases were good for mediation and the cases which were not good for mediation.
Well, let's talk about that for the viewers for just a minute. We're going to talk about the two main activities or processes that are involved in alternative dispute resolution, namely being mediation and arbitration, correct?
Correct.
All right. What is mediation?
Mediation it's a voluntary negotiation. Basically, it's just like the three of us sitting here, only the parties are involved, and usually the mediation takes place with you representing your client, and let's just say David representing his client, in separate conference rooms. Now, a mediator is someone who is in the middle, more or less, that is, going between the parties. A mediator is a neutral person, has no interest in the outcome, is simply interested in giving the parties the opportunity, creating the opportunity for the parties to have the best opportunity they can to settle a case out of court.
And are most cases that go through the mediation process, is there also a contemporaneous lawsuit that's typically pending, or maybe a contemplated lawsuit?
Exactly. I would say that most of the time, probably 80 to 90% of the time, there is an actual lawsuit that has been filed, and the parties are working to try to get that lawsuit resolved. There are times, however, when the lawyers and the parties understand that, hey, look, before a case gets filed, maybe it's to our mutual advantage to try to resolve cases out of court through the mediation process.
And the two ways that lawyers who are representing clients can get to somebody like you is they can talk and voluntarily agree, hey, let's hire Ken Simon as
Correct.
the mediator. Let's go visit Ken Simon for a half day or a full day.
Right.
Let's see if he can help us resolve this dispute. Or if a case is pending before a judge, that judge can actually order mediation, which has become more and more common these days.
Well, that's exactly right. Those are the two best ways. And let me just comment on the, let's say, judicial mediations or mediations which have been ordered by the judges. Any party can make a motion, can file a motion for the judge to order mediation. If a party does that, that party basically assumes the obligation of making sure that the mediation takes place and that party has to pay for the mediation. I have to tell you, as a mediator, I do expect that my fee will be paid. There is a charge involved. But more often than not, the parties get together on their own and voluntarily agree to do the mediation, and they usually agree to divide that expense.
All right, let's step aside. We'll take a break right here. Our first break of the evening is coming up now. As we head to break, a reminder of how you can join the conversation, take advantage of those opportunities. Also, the opportunity to speak with an attorney standing by live right now. Also, you can find the firm Hollis Wright on Facebook. Just search the term Hollis Wright. Great site and a great way to keep up with some legal happenings and things that we believe you need to know. And also on Twitter, it is Hollis_Wright. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Read those contracts carefully. Good piece of advice. Welcome back into the attorneys. You can join the conversation, call, text, email, that information on the screen all throughout the program. We'd love to get your feedback. Got a question here. Can a mediator decide who wins and who loses a case?
Well, if I may answer that, no, the mediator does not make a decision like that. It's a voluntary process. It's not a binding process.
Okay.
All that means that it's really up to the parties. It's your case. I can't force, Carter, a settlement on you or on you, David, if you're representing someone. The best I can do is try to persuade people that it's in their interest to resolve a case.
Right.
Now, what normally happens is that you will have your goals, you and your client will have your goals as to the outcome that you want, and you, Carter, will have your goals. So there's almost always a gap between those goals. So my job then, and where I try to earn my money is by trying to help the parties come to a point somewhere between those two positions where they both can see, okay, this is not exactly 100% what I want, but it makes sense for me to do this. And so when both sides come to that point and that realization and that understanding, then we can usually get a deal.
Can I ask both of you, because you both do this a good bit in terms of negotiating between parties. I'm fascinated with the negotiation process is a part of kind of the art and the science of it. Is a part of it removing some of the emotion from it, because oftentimes that makes it so much more difficult, but also helping folks see where they agree and where there is the common ground, because whenever there's emotion involved, I may not ever want to agree to what's good for you. Is that the art science balance?
I think it's all of the above. I think one thing that Ken brings to the table is he's 100% objective.
Right.
The client is certainly not objective, and I'm not really objective either. I'm probably a little more objective than the client because I'm not emotionally involved from the standpoint it didn't happen to me. But the reality is Ken Simon or any mediator are 100% objective. They're looking at it independent. Part of their job is to help remove the emotion from the situation and help the parties focus on the actual facts of the case.
That's well said. I recognize as a mediator that the lawyers not only are objective, but they're also advocates, which means that when they come to a mediation, their clients expect them to speak up for them. So I recognize that the lawyer at certain points, can only push the client so much.
Right.
So it's my job then to bring my experience and hopefully my objectivity to the table and to try to counsel both parties in a way that's mutually beneficial.
Right.
Ken, is the mediation process confidential, and can the parties or lawyers be prejudiced in any way by going through the process? And the reason I ask that question is a lot of times when I'm mediating a case on behalf of a client, one of the questions they ask is well, if we tell them here that we might be willing to take a certain amount to settle the case and it doesn't settle, are they going to use that against me in court?
Well, that's a great inquiry, and I'd say it is a deterrent to parties coming to the table to mediate. That is, they're concerned about the very point that you've raised, that if you make a settlement proposal, now is that going to come back to haunt me? I'm thinking if I'm a lawyer, is that going to come back to haunt me before a jury or before a judge? So recognizing that, our mediation rules say that it is a confidential process, meaning that what is said during the mediation, the proposals that are exchanged during the mediation, stay in the mediation. And we all are bound, the mediator as well as the lawyers and the parties, are not allowed to disclose to a judge or jury or really outside the mediation context what their positions are or information that has been exchanged during the mediation for purposes of getting the case settled. That can't come back in a way that you don't consent to.
Well, what types of cases are you mediating typically? And if you're not mediating it, are there other areas of the law where mediations are held? For instance, I know that you mediate a lot of personal injury type cases and business disputes, but do people mediate divorces?
People do mediate divorces. In fact, there's almost no type of civil case that can't be mediated. Let me just give you an example of what we mediated over the last week or so. I was in Montgomery last week, and we mediated 3 cases that involved teacher discipline. In other words, there were cases which had been brought by the State Board of Education. I don't think I'm disclosing anything that would be confidential. The teachers involved were not on board with the discipline that was proposed. So we found a way to mediate and try to resolve those cases. The last case I mediated was not a personal injury case, but instead it involved a claim by a car buyer. The car buyer said, hey, look, you sold me a car that was a lemon. The engine was defective and gave out on me. So that gave the parties an opportunity to come together at the table to try to find a way to resolve that particular claim, and we were successful in getting that done.
And Ken, you're so good at this, that is an excellent segue into our next topic, which is arbitration, because you mentioned somebody buying a car, and let's talk a little bit about arbitration. What is arbitration?
Okay, well, the car scenario is the perfect scenario to discuss this topic. Arbitration is a situation where the parties really don't have a choice most of the time about whether or not to use arbitration as a way to resolve their disputes. In other words, if you buy a car, David, you go down to Hoover or you go out to Irondale or here on the south side to try to get a car, most of the time you're not going to be able to make that purchase unless you agree to arbitrate any dispute that you might have. So whereas, let's say 20 years ago, 15 years or some years ago, you may have been free even after you bought the car to file a lawsuit if you felt that you had been sold a lemon.
Right.
Today, that's really not the normal situation. The normal situation is that you would have to agree to binding arbitration. So someone like me, an arbitrator, would serve as the judge and jury in that case. The arbitrator would decide what the facts are, what the law is, and then render a ruling in response to the case put on by the parties. So that's the arbitration process.
And so essentially it is a trial, it's just you're going before an arbitrator as opposed to a judge or a jury, and unlike mediation, you get to decide who wins and who loses.
That's exactly correct.
All right, let's step aside right now. We'll take a second and final break of the evening. As we do so, a reminder of how you can join our conversation. Would love to hear from you. Also, find the firm there on Facebook and Twitter. Stay tuned. The final segment of The Attorneys coming right up. I'm Tyler Vale with the law firm of Hollis Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 411, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm? Recommendations from friends or family? The internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? Do your research. Look the firm up on the internet. Ask friends and family whether they know or have any experience with a specific firm. If you know any local lawyers, ask them about the reputation of the firms you may be considering. Call a local law office and ask if they are handling cases like yours. There's a good chance they can help you. But if they can't, they can always refer you to someone they respect who handles your type of case. And remember, ask questions face to face. Ask about their experience in handling cases like yours. How often someone from their office will be available to you, and what you can expect during the process. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. back into the attorneys, our final segment here. So the numbers you see on your screen, if you have a question, take advantage of that opportunity to get those into us. Also, an attorney standing by for just a few more minutes. So if you have a question, or as we've talked tonight, maybe a question has come up that you would love to run by an actual attorney, your opportunity right now to do so. Carter?
Yeah, Ken, you mentioned a minute ago before we took a break that car dealerships often require or impose an arbitration agreement in their purchase agreements with individuals buying cars. What other areas are you seeing arbitration agreements? I know from my practice, I'm familiar with them being in nursing home agreements where people are being admitted into nursing homes. Do you see that in a nursing home setting, and what other settings?
Well, I can give you a few examples. The nursing home setting is in fact one. I have served as an arbitrator for a claim that was brought by a nursing home patient, actually a couple of cases that involved arbitration. And it's very strange, it seems, to be arbitrating cases involving personal injury claims like that, but it is a fact of life today. We normally see arbitration in the commercial setting. In other words, if you have a dispute between, let's say, a home builder and an owner, you're probably more likely to expect arbitration in that setting. Traditionally, that's where arbitration was usually found. Also in the labor area of our economy, labor unions and the employers are accustomed to it. But we've seen in recent years that arbitration has expanded to non-traditional areas, that is, into the consumer area. And that means that we've seen them on a growing basis, as we've mentioned already, with respect to buying cars. We see them with respect to any cell phone purchase that you might make. We see them in connection with loans that you might take out with a bank. Just a variety of consumer transactions today can involve having an arbitration agreement as part of the process.
Now, when I file a lawsuit for personal injury on behalf of a particular client, let's say I'm entitled to conduct what we call discovery.
Yes.
I can get all the documents that are relevant from the defendant. I can take depositions of the defendant's employees if it's a corporation, or witnesses and things like that. What is allowed in an arbitration setting in terms of discovery?
Well, it's quite different. And the right to discovery that we normally would expect in a civil case, as you've mentioned, it's pretty broad. It's not the same way, however, in arbitration. In other words, the arbitrators get to decide how much discovery you get, and it's not governed by the same rules of procedure that we operate in when we're in court. So the arbitrators, they see their mandate and their job as being to limit the amount of discovery that you might undertake. So we might, for example, be accustomed to getting documents just by asking for them in writing. Well, you may not be able to get that in arbitration. You might be accustomed, if you're a lawyer, to getting a number of depositions in an ordinary civil case. Well, you might only get half of those in an arbitration setting.
And are there uniform rules and regulations that are out there that have been promulgated or generated to kind of control the discovery process within an arbitration?
Well, that would make it easy.
Well, you would think so.
Well, the short answer is no. And in fact, it varies by what we call the arbitration provider. So there are a number of providers of arbitration services. The one that most people are familiar with would be the American Arbitration Association. And there are many others out there who provide those services. I'm with a group that's called Judicial Arbitration Group. We're out of Denver mainly, but we're also now in the eastern United States, and that's where I operate. So the parties can agree ahead of time if they're going to be bound by a certain set of rules, such as the AAA rules, or they can agree to be bound by the federal rules or the state rules of procedure. But it's basically a collection of different rules, and there isn't any uniformity.
And who pays for the arbitration process? How does the payment and fee schedule work?
That's very much a hot button issue. Ideally, the party that made you sign the arbitration agreement is the one that ought to pay. It's not always quite that straightforward or simple, and that's a big problem Carter, with consumer arbitration. In other words, if you're buying a car, in order for you to exercise your right to present a claim, it's really burdensome and difficult for a consumer to be expected to pay for the cost of arbitration. So normally in that situation, the courts are going to say, you commercial provider, you vendor, you have to pay for this.
Because they're the ones that put it in there in the first place.
You got it.
Yeah. Just a couple of minutes remaining, so an opportunity for both of you. Just a final thought for our viewers, and Mr. Simon, if you would, you go first.
Certainly. I just want to say that we should all embrace alternative dispute resolution, because the goals and the purposes really are meaningful. I think we all recognize that, yes, it can take a long time to get through the court system, and you may not like the outcome once you've gone through it. Right. It can take a very long time, and even the trial may not be the end of it. You might end up going through an entire appeals process, and a court might say you've got to go back and retry that case. Mm-hmm. So that's not really a satisfactory or cost-efficient outcome for anyone. Right. So what I try to advise people to do is to think of it as an opportunity to control the outcome of this case. We can't make you in a mediation accept a proposal, but we can encourage you to look at the whole picture and recognize that you have today a certain outcome opportunity that will bring an end to this whole thing for you and limit your costs.
Very good.
Yeah, and I agree with everything that Ken said. I kind of look at this from a different perspective, because I'm not a mediator, I'm an advocate, I'm a lawyer on behalf of my clients. And I do think control is key. It's very important. The ease in which and a quick resolution is very important as well. And I think it's something that everybody should consider and talk with their attorneys about when they're being represented about, hey, is this eligible for mediation? Is this something that we can do? The only thing that I would caution against is that sometimes I feel like that parties are reluctant to try and settle their case outside of mediation, and it is almost expected to have to go to mediation every time, and that's not always the best route.
All right, gentlemen, thanks so much for the time. Appreciate both of you being with us. Also want to thank you for being with us tonight. As always, thank you so much. As we wrap things up, here's how you can get in touch with the firm of Hollis Wright. Again, thanks for being with us, and we'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.